Welcome to the 8th edition of World Intellectual Property Forum.
Hello friends, I am Divya Balasundaram, advocate and one of the founder partners of Inventure IP. We are an IP boutique firm located in Delhi NCR. I have also been an arbitrator with the National Internet Exchange of India for about 6 years. And having dealt regularly with .in domain name disputes, I decided to choose this topic for the presentation, touching upon the policy and procedure pertaining to such disputes. I hope you find it informative and interesting. Thank you. The domain name disputes, we have a lot of them. They basically arise over the overlap between trademarks and domain names. Both trademarks and domain names have a source identifying function, but domain names are not bound by country or jurisdiction. They can be accessed anywhere pertaining to any jurisdiction. And it's also not tied down to specific goods and services. To begin with the global policy, which is the legal framework for resolving disputes between a domain name registrant and a third party. It falls under the auspices of the Uniform Domain Name Dispute Resolution Policy, which was adopted way back in 1999 by the ICANN Board of Directors. This is basically for the generic top-level domain names, and it's administered by the WIPO Arbitration and Mediation Center. It's a compulsory dispute mechanism resolution. When a person purchases a domain name, this policy is automatically incorporated into the registration agreement, and the registrant has to compulsorily submit to the same. As far as India is concerned, we have a policy which was started in 2005, which was recently revised in September this year. It's administered by the National Internet Exchange of India, and it pertains to disputes arising out of .in domain names. Now, when we talk of the elements of the policy, it's overlapping or very, very similar between WIPO as well as what we follow in India under the .INDRP. The basic element is the domain name in question under dispute or which has been wrongly registered by somebody is identical or confusingly similar to the name, trademark or service mark in which the complainant has rights. The second element is that the respondent doesn't have any rights or legitimate interests in the said domain name. And the third one is that the registrant's domain name has been registered or is being used in bad faith. I will touch upon each of these elements in a little more detail. The first element, which is that the domain name in question is identical or confusingly similar to the mark in which the complainant has rights, is it threshold pressed? It is not only statutory rights of the complainant which can be protected, even common law rights can be protected, but the element of proof to show that the complainant has a standard or an extent of rights when it is not registered would be higher. It really doesn't matter in which country the registration was obtained or for what goods and services. What matters is on the date of filing the complaint, the complainant should have the rights in its name. When it comes to the test of what is identical, it's a fairly simple test. We don't take into account the .tld extension. When it comes to what is confusingly similar, the outlook adopted would be very similar to the test which we follow when we're comparing two trademarks. For example, misspellings, having a word but adding a very common prefix or a suffix which does not have a distinguishing element, typo squatting, which is having a minor change in spelling, adding a hyphenation between the words. All these will not really serve to distinguish the domain name from the trademark, and these are the factors which will be used to determine whether they are identical or confusingly similar. Website content, typically what happens is if the website under the disputed domain name is also pertaining to the similar line of business as that of the complainant, it becomes an added factor which adds to the confusion, but that is not necessary in the first element. As I had mentioned, the relevant date to determine the rights of the parties is when the complaint is filed. To move on to the second element, this basically talks about the respondent not having any rights or legitimate interests in the disputed domain name. Now, there is no hard and fast rule as to what is a right or legitimate interest. There are some illustrations that have been provided, but it's not an exhaustive list. What are the ways in which a respondent could show that he actually has a legitimate right or interest in that particular domain name which he has registered? So before getting a notice of the complaint that has been filed or the dispute between the parties, the respondent has used the domain name. There is a demonstrable preparation or reasonable preparation to use it with a bona fide offering of goods and services. Again, the term bona fide has its own significance. It has to be seen whether it's just spurious goods being offered, whether it's a way of bypassing by saying that we're offering these goods and services for sale. Another element which will show that the respondent did have rights is that he was commonly known by the domain name. It does not mean that he needs to have trademark rights in the same. It could be a name, it could be an acronym, it could be a nickname. But if the respondent is able to show that I was known by this domain name, even if it happens to be identical or confusingly similar, he would be protected against the complaint. This, for example, when we're talking of personal names, people do register their personal names both as trademarks and domains. This would be one illustration where you can show that you have a bona fide right in the domain. The use by the respondent has to be legitimate, non-commercial, or a fair use. It could be a fan site, it could be a criticism site, but as long as it's a non-commercial fair use, it's permitted. There are situations where there are bulk domainers. They aggregate and hold domain names typically for resale because it is legitimate to trade in or deal in domain names. But if they are only common phrases, dictionary words, or acronyms, it's per se not illegitimate. However, if it is infringing on a third party's rights, then we cannot call it a legitimate or a fair use of the same. One of the instances where one can distinguish whether the respondent's use is fair or not is if the respondent has simply parked the domain with a pay-per-click website, and if the links are related with the complainant's business or they capitalize on the complainant's goodwill, then it would be a problem area. But if it is not connected or it happens to be a blog, forum, or another informational page, even if there is some presence of pay-per-click links, it does not necessarily mean that there is a non-legitimate right on part of the respondent. We now move to the third element of the policy, which is the element of bad faith. Here again, the policy, the DOT and DRP policy, as well as the uniform policy, do provide instances which can show what constitutes bad faith, but it's an illustrative list, it's not conclusive. One of the illustrations provided by the policy is that the domain name is primarily registered to transfer it to the owner of the trademark or a competitor of the complainant for a valuable consideration in excess of the out-of-pocket cost directly related to the domain name. So when we're talking of the out-of-pocket costs, it's basically the cost for registering and maintaining that particular domain name. It does not connect with the website developed under the same or a portal developed under the disputed domain name. Another factor which would show bad faith is that the registrant has obtained the domain name only to prevent the trademark or service mark owner to reflect it in a corresponding domain name for their own genuine business, provided the registrant has engaged in a pattern of such conduct. And there are domain tools by which one can search the various domain names which have been registered by a particular party, and it can be shown that this person has blocked or registered domain names which are copies of trademarks of many companies, and it will show a bad faith conduct on the part of the registrant. If the domain name is registered primarily to disrupt the business of a competitor, or there is an intentional attempt to attract the internet users to your own website rather than moving to the complainant's genuine website for financial gain, or where you create an illusion of a sponsorship or affiliation or an endorsement of the complainant's business. In all these cases, it can be assessed whether there is a bad faith on the part of the registrant. Now, when we're talking about pattern of such conduct in the number of domains which have been owned or purchased in bulk by a domainer, if we're only talking about dictionary words or common phrases, it's not illegitimate and it may not necessarily reflect such conduct. But if the registrant has been using various company names and brand owners' names as their domains, it could indicate a bad faith conduct. The policy and its elements are based on a combination of elements from trademark law, the thought of passing off, principles of equity and natural justice, as well as consumer protection. The three elements which have been discussed and mentioned have to proceed on a case-to-case basis analysis. There is no one glove fits all situation or solution. There is a situation where there is a duty implied on the registrant, especially in the internet age where a simple Google search will reveal whether a particular trademark is owned by somebody or not, to do a preliminary search, preferably, if it was reasonable within means to do it, to show a good faith on the part of the registrant. Sometimes a question arises as to whether delay is a factor in preventing a favorable order. It is not. We have also spoken about pay-per-click web pages where there is a website. There may be situations, and there are several situations, where a domain name is simply registered and there is no website associated or connected with the same. But a non-use or even a passive holding can indicate bad faith. The other important element to note here is that all the three elements have to be established by the complainant in order to get a favorable order. It is not that one is met and the others are not met. It would not be sufficient. It's not necessary that when there is a lack of response by the respondent, it's automatically imputed that he doesn't have a defense and the complainant should be given the order in his favor. The arbitrator or the panel will still have to assess and see whether all three elements of the policy are established. We also need to note this term or this element of reverse domain name hijacking. When we're talking about equity and natural justice, it is not only equity and natural justice in favor of the complainant. In case there has been a bad faith on the part of the complainant to abuse the UDRP process to deprive a registered domain name holder of a domain name, the panel may hold that there has been a pattern or a behavior of reverse domain name hijacking on part of the complainant. This is not a situation where the complainant simply does not succeed in getting a favorable order. It indicates a bad faith beyond this. The domain name dispute resolution, I would also briefly touch upon the administrative aspect or the procedural aspect. I will now briefly touch upon the administrative procedure in filing a complaint and dealing with a dispute. It's a fairly simple, quick and time-bound procedure. The complainant needs to file a complaint with the WIPO or a WIPO authorized panel in different countries. For example, in India, it's the National Internet Exchange of India, which is the body which looks after these disputes, which administers the disputes. The NICSI will then check the complaint and the documents for the formalities and procedural requirements. If that's in order, they move to appointment of the arbitral panel, which is typically a sole panelist. It could be a 3-member panel in certain circumstances. The arbitrator then issues the notice to the respondent and calls upon him or her to file a response. Again, it's usually a shortish time frame of around 15 days to 3 weeks. In case there is no reply, or if there is a response after consideration of the same and when the time is elapsed, the order can be passed and the rights are limited to either cancelling or transferring the domain name, and it's not any other kind of remedy which is requested or allowed under this procedure. As regards the case law, under each and every single element as well as the procedural aspect, one can refer to the WIPO overview and the panel view, which has several cases which talks about the different elements, what are the requirements. For example, there will be a segment on where a mark is well known. Then there is a presumption of bad faith if a registrant has adopted the same. As mentioned, these are all on a case-to-case basis, and the facts of each case would be different. And there is no standard case law which would be applicable to different situations, but this would serve as a very good guideline to assess the various aspects which crop up under the policy. For India, we can refer to the registry.in website. Under the dispute resolution category column, there are more than 1,000 awards which have been passed by the arbitrators which are uploaded, and that would give us an indication or a deeper understanding of how the policy has been interpreted by the panelists over a period of time. So thank you for this presentation, for the opportunity for the presentation. And in case of any questions or clarifications, I'm open to a discussion and we can have an interactive session to clear the doubts on the same. Thank you so much.